But then other people say, now, wait a minute. Maybe that'll happen, but the law is the law. The law is the law. And if Donald Trump, and that's basically what that 126-page article by the two conservatives said. The law is the law, and we shouldn't, use prudential concerns and worries about the future, and we shouldn't make exceptions and all of that. To which I respond, the law is absolutely not the law.
Welcome to Law and Chaos. Last week, the Supreme Court heard oral arguments in the case seeking to throw Donald Trump off the ballot in Colorado for committing insurrection on January 6, 2020. Also last week, former Brazilian President Jair Bolsonaro surrendered his passport as the government of that country investigated him for the coup he attempted on January 8, 2023. What does it say about American democracy that we're having a legalistic debate about letting an insurrectionist run for office again? And how is the Supreme Court going to rationalize letting it happen? I will discuss that today with law professor and constitutional scholar Eric Segall. We've got a lot to cover, so let's get after it. Hey guys, it's Liz Dye. Before we get to the interview, I would like to read you something I wrote on December 15, 2020. It was an article at Wonkette where I made fun of the slates of cosplay Trump electors from Arizona, Michigan, Georgia, Nevada, Pennsylvania, and Wisconsin who had just sworn themselves in that day like they were the real deal. They claimed that they were doing it to preserve their claims if and when something, which at the time seemed like the funniest underpants gnomes joke ever. Let me read what I wrote. In reality, there's nothing to preserve procedurally or otherwise. Trump and his allies filed dozens of suits across all these states, and the courts told him to GTFO because he had no evidence of fraud. The Electoral College met yesterday, and they cast their votes. If Representative Mo Brooks wants to continue this charade, and if one Republican senator wants to play along with him, they might succeed in delaying the certification on January 6th by a couple of hours. But that's it. Not sure where there's internet rumor about Mike Pence breaking the tie came from. Paint huffers, probably. Over in Arizona, the Gippers aren't going to let a little thing like objective reality interfere with their dress-up party, though. In fact, they took it to a whole new level. Not only did the state party meet to cast a pretend vote, but a bunch of even loonier lunatics who describe themselves as sovereign citizens of the great state of Arizona dummied up a fake certificate of ascertainment, notarized the thing, and sent it to the National Archives. We've seated before the legislators. Here, we've already turned it in. We beat them to the game, Lori Oziecki of the group Arizona Protect the Vote told Arizona Central, before returning to an animated discussion with a little man who lives in her feelings and tells her not to trust the fake news media, allegedly. Apparently, this group thought Arizona's Republican Governor Doug Ducey wasn't breaking enough laws to help Trump steal the state's 11 electoral votes for Trump, so they took matters into their own hands. Presumably, this did not extend to forging Governor Ducey's signature on their bogus certificate since they're not currently under arrest, which means that they and the rest of these sore loser loons are free to walk among us. So be careful out there, but don't worry about these jackasses successfully stealing this election. It's all over but the whining. End quote. So obviously, that was not my best take. I was mean, and I stand by that part. But I thought it was all over, and obviously it was not. I'm reading this to you today to make a point, and that point is that we no longer have the luxury of rolling our eyes and ignoring arcane minutia and assuming that things will work out as they always have. I took it for granted that whatever was supposed to happen in Congress to make Joe Biden president would just happen. And so this weird dress-up elector shit going down in the swing states was simply a real funny joke. And I was completely wrong. I didn't see what was coming just 3 weeks later because I wasn't looking for it. It did not occur to me that Trump and his goons would be parsing the language of the Electoral Count Act of 1887 and using a 130-year-old law to try and overthrow democracy, which is a long way of saying that the next lesson in the Trump School of Law is Section 3 of the 14th Amendment. And no, you can't skip it and assume that this will all work out because it always has before. That's just not the country we live in right now. And even if we get through this round unscathed, you still have to pay attention. So briefly, before we get to the discussion with Professor Segall, let's talk about the issue here. It involves the 14th Amendment, which was passed in 1868 in the wake of the Civil War to knit the country back together as a body politic. It applied the Bill of Rights, that's the first 10 constitutional amendments, to the states, and it clarified that anyone born here, including formerly enslaved people and their descendants, were citizens under the law. And if they were male, they were entitled to vote too. There is just no understanding this current debate without acknowledging that this is legislation arising out of the Great Culture War with the goal of making sure that we never again ended up divided against ourselves with racist demagogues rising up and trying to tear the country apart. And specifically, Section 3 was drafted to keep former Confederate officials from participating in government, in case they got any bright ideas about trying that shit again. And it makes sense, right? You don't get to participate in a government you tried to overthrow. So, okay, with that in mind, let's read Section 3 of the 14th Amendment. The first part involves the offices that you cannot hold if you've tried to rebel against the government. It says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state. So there's some debate as to whether that even includes the president. You'll note that it says elector of president and vice president or any office under the United States. But let's leave that parsing of the language for a second. Moving on. You can't be president if, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States. Okay, so that's a prerequisite. They could have applied it to everyone who fought in the Confederate Army, but they did not. They said if you previously held office, this statute applies to you. And we're, again, not going to get too deep in the weeds here, but I'd like to flag two issues that have kind of occupied the minds of law professors debating this issue. The first is a question about whether the president is an officer of the United States. It's like saying, well, the owner of the company isn't technically an employee. It's not a one-to-one analogy, but okay, there it is. I personally think that's kind of a red herring. And I think that as well about the second argument about whether Trump, who, unlike his predecessors, never held public office before, being in the White House, he never previously took an oath. So if getting sworn in as president doesn't count because he's, the boss, he's not an employee, then maybe he never took an oath and maybe this law doesn't apply to him and maybe he can't be barred from holding office. Again, I don't love this argument, but I flag it because it's dominated the discourse before last week's Supreme Court hearing. Going on. You can't be president if you previously took an oath to support the country and have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. Now, that's language which everyone in 1868 understood perfectly well. But it's kind of a moving target in the year 2024, right? Was what Trump did insurrection? A lot of people say no. A lot of people say yes, but it's not as clear, right? In 1868, they were like, hey, were you a Confederate officer? If yes, then get out. Okay, finally, there's this little throwaway clause that says, unless Congress says, nah, it's cool, bro, okay? It says, but Congress may, by a vote of 2/3 of each house, remove such disability. And we'll talk about that in the show when Professor Segall and I talk about whether Congress could kind of decide that that's what we're talking about. So when Trump declared his candidacy in 2022, a bunch of people said, wait a minute, this guy participated in an insurrection. He's ineligible to be president, same if he was like 29 and born abroad. No insurrectionists allowed. That's the law. And they filed lawsuits in every state trying to get him tossed off the ballot. In Colorado, the named plaintiff is a 91-year-old Republican lady named Norma Anderson, who spent 20 years in the state legislature with stints as majority leader of both houses. So she's no liberal squish, right? And most of the plaintiffs in these state-level cases are Republicans because we're talking about the Republican primary, and they're the ones with a stake that gives them standing to sue. So the trial judge held several days of hearings and made a finding of fact that Trump did engage in insurrection, but as a matter of law, the president is not an officer of the United States, and thus Trump had to stay on the ballot. The Colorado Supreme Court overturned that second part and said that Trump was ineligible for the ballot, and then Trump appealed to the Supreme Court technically, he filed a petition of certiorari on the very broad question of, did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential ballot? Which is, it's not a specific technical issue. It's a wide open invitation for the high court to overrule the state court on any grounds it wants to. The president is not an officer. Trump never took an oath. January 6th was an insurrection. Congress is the only one who can act here. Trump doesn't care. He just wants the win. And that is the problem, because that case, which is captioned Trump v. Anderson, went to oral argument on Thursday. And it's very clear from the justices' questions that the Supreme Court is not going to throw Trump off the ballot. It was fun. It was fun to talk about this in the media for a long time. But, 6-3, like math is math. The problem here is that they might punt. Most people think after the oral argument that they won't, but they could take some kind of off-ramp that kicks the decision to Congress without deciding whether Trump is or is not an insurrectionist ineligible to run for president. And at that point, we will find ourselves in January of 2025 in a very dangerous place if Trump wins. Here's an excerpt from an amicus brief filed by Edward Foley and Rick Hasen, those are two law professors, and Benjamin Ginsberg, a Republican election lawyer. They say, to punt on the merits would invite chaos while risking great damage to the court's reputation and to the nation as a whole. The country is more polarized today than at any other time in living memory, certainly more than in December of 2000, when this court last decided a case with a direct impact on the outcome of a presidential election. Controversy over the 2020 election led millions of Americans to doubt the integrity of the electoral system and ultimately culminated in the storming of the U.S. Capitol on January 6, 2021. Political tensions have not eased in that time since. Quite the opposite, political discourse has stoked further public skepticism of the electoral system since January 2021. Amici thus filed this brief not only to demonstrate that the court can reach the merits of Mr. Trump's qualification under Section 3, but that it should do so or else risk political instability not seen since the Civil War. The possible scenarios, if the court fails to resolve the Section 3 question once and for all, are alarming. If Mr. Trump wins an electoral vote majority, it is a virtual certainty that some members of Congress will assert his disqualification under Section 3. That prospect alone will fan the flames of public conflict. But even worse for the political stability of the nation is the prospect that Congress may actually vote in favor of his disqualification after he has apparently won election in the Electoral College. Neither Mr. Trump nor his supporters, whose votes effectively will have been discarded as void, are likely to take such a declaration lying down. Even if Mr. Trump did willingly stand aside, it is wholly unclear who would be inaugurated as president on January 20th, 2025. Would it be Mr. Trump's running mate pursuant to the 20th Amendment? Would it be Mr. Biden pursuant to a 12th Amendment election in the House? Or would it be some alternate candidate thrown into the mix in the heat of a public battle? The chance that there would be no clear answer come Inauguration Day 2025 and that the country thereby would be thrown into a possibly catastrophic constitutional crisis is disturbingly high. So, when I say to you that we can't tune this one out and assume it'll be fine, that is what I mean. Those are the stakes. We saw it 4 years ago, and we might well see it again. And with that, let's get to this interview with Professor Segall. And we're back. With us today is Professor Eric Segall, the Ashe Family Chair Professor of Law at Georgia State University. He's the author of 2 books on the Supreme Court, Originalism as Faith and Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges. And on top of all that, he is very good on social media. Professor, thank you for coming. How are you?
Thanks for having me, Liz. I'm doing well. It was quite a week last week, so it's nice to talk about it.
Yeah, so set the table for us. What happened Thursday at the Supreme Court?
Well, just one of the most important oral arguments maybe in American history. And before we get into the substance of it, I do want to climb on my hobby horse and say, listening to it was okay. We need to see it. This is a taxpayer-funded institution. It's a public hearing. There are members of the public in the courtroom. C-SPAN is willing to televise it at C-SPAN's expense, as I'm sure so are Fox and everybody else. There's no excuse, especially with the younger generation being such a visual generation. I want to teach this case next year, 2 years, 5 years, and I want to show my students the argument. I can play it for them. That is not the same as seeing it. So I want to make that point. Okay. So after the Civil War, it was decided, and the 14th Amendment reflects in Section 3 the idea that people who fought for the Confederacy should not be officers of the United States, should not be members of Congress, et cetera, et cetera. So Section 3 of the 14th Amendment says, if you have taken an oath to uphold the Constitution, which almost every public official does, and you engage in insurrection, then you're disqualified from holding further office unless Congress, by 2/3 vote in both houses, relieves that disqualification. Congress did pass laws, a couple of them in the late 19th century and 20th century, relieving the Confederates of a lot of the disqualifications. So the question is, did Donald Trump engage in insurrection on January 6th or any other time, and is therefore not qualified under Section 3 to be the President of the United States? Now, there's a lot of legal stuff going on, and we can get to that in 1 minute. But I do want to say, I've been saying for months, the Supreme Court's not going to save us. The Supreme Court, when I say save us, I'm talking from the perspective of someone who does not want Donald Trump ever to be president again. The Supreme Court is not going to disqualify him. That was clear to me 3 months ago. After Thursday's argument, I don't know anyone. I've not yet seen a single commentator after Thursday's argument who thinks the court is going to disqualify him. It is unanimous, unless they come with a big surprise, that they are not going to disqualify him.
Right. I think the only justice who appeared to have any appetite for that was Justice Sotomayor. It did not appear that Kagan or Justice Ketanji Brown Jackson had any interest in this exercise. I
agree with that. And I predicted a month ago that it would be 8-1 with Sotomayor dissenting. So that
good on you.
Well, who knows? But I know Justice Roberts is going to try very hard to make this unanimous. We'll see if that works. Can we talk about Justice Jackson for a second? Because she did something really interesting. And I think your audience, even separate from Donald Trump's disqualification, might find this interesting. I have written a lot of articles in my career and done a lot of podcasts and other media where I've said the Supreme Court doesn't care at all about constitutional text. That's the Supreme Court of 1803, 1850, 1900, 1950, and today. One difference is the Roberts Court pretends really deeply to care about text, but they don't. I could give your audience 25 examples. Just bear with me for a second, though. Justice Jackson really bore down on the text of Section 3. And what she said was, she said to the lawyers, I don't understand. It lists members of Congress, the House, the Senate, state officials, the electors to the president. Those are the people who cast the electoral college votes for the president. It doesn't mention the president or vice president specifically.
Yeah. And you know what? Let's play a little clip of that.
Yeah, so I had a question about it because you're making a textualist argument. And as I look at Section 3, I see two parts of the first sentence of Section 3. The first is a list of offices that a disqualified person is barred from holding. And the second are specific circumstances that give rise to disqualification. So first, am I right about seeing that there are two different things happening in the first sentence of section? Okay.
For sure.
So are you arguing both in this case or just one? Are you arguing both that the office of the presidency should not be considered one of the barred offices and that a person who previously took the presidential oath is not subject to disqualification?
We are arguing both, Your Honor.
I don't see that in your brief. I see a lot of focus on the second, but not on the first.
There is definitely more focus on the second, and we acknowledge that we have a somewhat heavier lift on the first point.
Why? It seems to me that you have a list and president is not on it.
That's certainly an argument in our favor, but there are also, with respect to officer of the United States, that's used repeatedly in the Constitution, in the Commissions Clause, in the Appointments Clause, and also in the Impeachment Clause. And every time it appears, it's used in a way that clearly excludes
No, I understand, but that's the second argument. So the first argument is we have a list of offices that a person is barred from holding, right?
Yes.
Under your theory or under the language of, and we see it begins with senator, representative, elector of the president and vice president, and all other civil or military officers.
Offices under the United States.
Offices under the United States. But the word president or vice president does not appear specifically in that list. So I guess I'm trying to understand, are you giving up that argument? And if so, why?
No, we're not giving it up at all. You're right. The president and the vice president are not specifically listed. But the Anderson litigants claim that they are encompassed within the meaning of the phrase office under the United States.
And do you agree that the framers would have put such a high and significant and important office, sort of smuggled it in through that catch-all phrase?
We don't agree at all.
Okay. So she is very concerned that the president is not listed in Section 3. Mm-hmm. She should be concerned. We all should be concerned. Now, I think the history shows they intended the president to be covered by Section 3. The history shows they would never have wanted Robert E. Lee to be president of the United States. That's Mark Graber, professor at the University of Maryland, along with he's a liberal, but along with two very conservative law professors, Michael Paulson and Will Bode, who wrote the original 126-page opus that started this entire round of this enterprise. They all think that it was obvious that they meant the president. And I think that too. But it's not what they said.
Right. It says electors for the vice president and the president.
Yeah.
It does not say the president. And that, as you said, sparked this kind of debate between law professors that's been going on about whether the president is an officer or an officer under the United States. And I worry because I feel like that seems like, angels dancing on the head of a pin. It's very hard for people to understand this discussion. Normal people. Not that law professors are not normal.
Right. No, we're not. We're definitely not normal. But
exactly.
But that wasn't Justice Jackson's point. It wasn't that the president is not yes. Her side point was the president is not an officer because Section 3 does apply to officers of the United States. But her main point was why list all of these other people and not list the president if you want the president covered. Now, my only point about this is if the Supreme Court cared about text, they would take that argument very, very seriously. I don't think, because again, it's what they wrote, not what they meant, that we're concerned about. The problem is the we in that sentence is me and you. Let me just give two real quick examples about the Supreme Court. The 11th Amendment says states can't be sued by citizens of another state. It's not ambiguous. It's not imprecise. It's not like due process, equal protection, words we can't define. No state shall be sued by citizens of another state. Supreme Court has said the word another state means the same state. And that can't mean that. It just can't. Another can't mean the same.
Right.
Well, it can't.
Right. It kind of reads a sovereign immunity into the statute, which isn't there.
A sovereign immunity from suits by citizens of other states, but not by your own states. A more perplexing example, maybe, is Congress shall make no law abridging the freedom of speech. All right. It says Congress. Now, we know we can apply that to state legislatures under the Due Process Clause of the 14th Amendment. The Supreme Court said all of the Bill of Rights, or most of them, apply to the states. I get that. That's fine. But how do we get from Congress to a state governor or to a state judge or whatever? You can't. There's no way to get from the First Amendment does in our country apply to state governors. Supreme Court, it does. But it can't. It says Congress. My point there is the court doesn't care about text. I wish the Roberts Court would stop pretending that it cares about text. Justice Jackson does.
Amen to that. Mm-hmm.
Justice Jackson does care about text, which is why she was focused on that omission. But that's not how the court's going to decide the case. I think we know how the court's going to decide the case, and I agree with it. The court is going to say we can't have 50 different states disqualifying different people on different grounds with different procedures, especially for a national election. That's just impossible. They're going to say, I think, Congress has to pass a law authorizing disqualification, authorizing procedures for disqualification before states can disqualify people running for federal office. Colorado can clearly disqualify people running for state office in Colorado under any number of provisions, including Section 3 of the 14th Amendment. But the argument's going to be, and all the justices, Justice Kagan, to my surprise, Justice Jackson, all of them were very sympathetic and worried about this idea of what do we do with different procedures in Colorado and New York and Massachusetts and Florida. So they're going to say Congress has to pass a law. Now, the Roberts Court is very clever about this. They always know that when they say that, no law can be passed.
Right.
And people might remember the horrendous decision in Shelby County that gutted the Voting Rights Act. Mm-hmm. Technically, it didn't declare it unconstitutional. It said this version is unconstitutional. Congress can come in and fix it. But Justice Roberts knew with every fiber in his body that with the filibuster in the Senate, there was no way that Congress was going to change it. Same here.
Yeah. So let's double back. So explain in detail how you think the Supreme Court is going to do this offering, because there was a lot of back and forth, and Justice Jackson said, well, this doesn't apply to the president, and Justice Kagan was talking about the unworkable nature of this happening. And actually, let me flag for a second something that Justice Alito said, because he's a cantankerous old sumbitch, as I hope
he's a troll.
Saying.
He's a troll.
Yeah, he is. And one of the things that he said was, well, suppose there was a president who unblocked aid to one of our foreign enemies and gave a bunch of enemies cash, wink, wink, obviously implying, the release of Iranian confiscated money by President Obama. What if that counts as an insurrection and, other states like red states try and, disqualify this president? And I think that was an absolute troll. But I will say that I do take the point, and Justice Roberts was a little less trolly about it when he also made it, that if blue states start disqualifying the president, disqualifying Trump for what I would agree is insurrectionary behavior, red states are going to do it, and they're going to stretch that aid and comfort part of the 14th Amendment, Section 3, to cover more or less anything.
Yeah, I agree with that 100%. I am concerned about that as well. It just so happens, I think we can agree that as of this date, maybe this will change in the near future, the Republican Party uses these kinds of weapons much more effectively than the Democrats. How do we know this? We know this by the fact that there's a 6-3 conservative majority on the Supreme Court of the United States. But if you look at the last 50 years of presidencies, it really should be even. It shouldn't be that much of a discrepancy. Right. We know what McConnell did. We know what they're capable of doing. So I was always concerned with that. Let me give you the response to our concern and then my response to that response. So the response to what you were saying and what I'm saying and what Justice Roberts and Alito was saying in his very trolly way. Let me just promote my blog. I have a blog post out at Dorf on Law. It came out on Monday.
We'll link to it in the show notes.
That talks about Alito being a troll and doing all this. But but you said it perfectly. The concern is valid. The example was terrible. The concern is valid. But then other people say, now, wait a minute. Maybe that'll happen, but the law is the law. The law is the law. And if Donald Trump, and that's basically what that 126-page article by the two conservatives said. The law is the law, and we shouldn't, use prudential concerns and worries about the future, and we shouldn't make exceptions and all of that. To which I respond, the law is absolutely not the law. One of the things they say is if Donald Trump was 32, we wouldn't be having this conversation. He couldn't be president, and of course the states could disqualify a 32-year-old. Or if he was not born in America, if he was, a foreign citizen born in England, again, we wouldn't be having this conversation. But there's a slam dunk response to that, I think. And I think at least two of the justices said it on Thursday. Yes, but we know what 35 means. We know what being an inhabitant means. We know. Might there be conceptually a close case somewhere? Maybe. But 99.9%, there never has been, right? About 35. I mean, every president's been 35 or not. Natural born citizen, we've had a couple of debates, but not real debates, right? Nothing real. The definition of insurrection is not like that. It is not a self-defining qualification for the presidency. Being 35 is. Being a citizen of the United States is. Engaging in insurrection is not. Now, there are some things that are clearly insurrections. The Civil War. There are some things that are clearly not insurrections. Justice Alito's absurd example. But there's a lot of things in between. And I think what Justice Roberts and Kagan and others were concerned about was that in-between part of defining insurrection is where I think both red and blue officials will abuse their authority, disqualify 100%. People without... Now, there's always judicial review, but that's messy and complicated and takes time. So I am very concerned about that. Now, the last response they make, and it's a sophisticated one, is, okay, so Congress passes a law satisfying Kagan and Roberts and Segall and Dye. Congress passes a law authorizing...
Congress passing a law is not something that happens all that often now.
But even if they did, the argument is it wouldn't solve these problems. There'd still be 50 different states. But at least then we have an explicit authorization by Congress to do it. And that's what Section 3 to me seems to call for. Where I disagree vehemently, and I actually was at Stanford with Will Bode, who co-wrote that first article, and Michael McConnell, who's a famous 10th Circuit judge, now a law professor at Stanford, one of the great originalists, sincere originalists of our time. There aren't that many sincere originalists. He's one of them.
I would agree with that. Yeah,
he's one of them. So in a debate I had with the two discussion I had with the two of them. We were talking about all this, and really, unless the insurrection is crystal clear, this provision should not be used. And to the extent there were people who broke into the Capitol on January 6th and committed acts of violence, that was an insurrection. And if they took oaths to uphold the United States, they should be disqualified.
Right, like Coy Griffin in New Mexico.
Exactly. Yes. Donald Trump's January 6th speech, while despicable, awful, terrible, and by the way, in my opinion, not protected by the First Amendment, others would disagree. Most Americans would disagree with that. But whatever that wasn't insurrection, or at least that's not clearly insurrection to me. And again, someone who has 70 million supporters, a former president, the presumptive nominee of the Republican Party, the only way to disqualify such a person is to be clear. Last point about this. I know Will Bode very well, the co-author of that big article. I know Michael Paulson very well. He and I actually once made a law together at the Department of Justice many years ago. Before delegation was a problem, he and I made a law together. But in any event, I know them both very well. Their article, which I wrote about right after it came out, is just they're both brilliant law professors, but they were too certain. There were so many issues they were certain about, and I pointed this out in an early blog post response.
This was the article about the officer, not officer?
No, it was the article about everything. The very first article that came out was by these two Federalist Society conservatives, very prominent in con law circles, one of whom clerked for Justice Roberts, who wrote this 126-page article saying Trump is disqualified now. We don't need any procedures. We don't need any hearings. He committed insurrection. It's like he's 33. They said if he was 33, he'd be disqualified now.
Yeah, and let me just break in because that was in the oral arguments. That was where our guy or the attorney for Norma Anderson, the plaintiff in Colorado, that is where I think he was weakest because Justice Gorsuch managed to corner him and he did not have a good answer. Let's play a little clip of that.
Could I ask you again the question that Justice Gorsuch asked, to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Why not? Because you say he's disqualified from the moment it happens. Now, I understand the de facto officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he's in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly, Congress could impeach a sitting president, but that's the only remedy I'm aware of that exists for removal or otherwise negating the authority of a sitting president.
Why? Well, on what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless...
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is the
No, de facto, that doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside, okay? I think Justice Alito is asking a very different question, a more pointed one, and more difficult one for you, I understand. But I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
So just to break that down, if Section 3 means a person who engages in insurrection is immediately disqualified, Justice Gorsuch is saying if Trump committed insurrection on January 6th, were not all of the things that he did after that, between the 6th and the 20th, when he left office, were they not non-illegal? Was he still the president? And could someone say, I don't have to listen to you because you're not the president, you're an insurrectionist? And I don't think that Murray, the attorney for Norma Anderson, had a good answer there.
I'm not sure, Liz. Maybe we can reasonably disagree on that. I think I remember him saying something to the effect of, and maybe going back to the transcript, I'll be wrong about this, but I think what he said, or at least what a possible answer is what legal effect disqualification has on a current office holder. For example, Donald Trump post January 6th until January 20th, those 13 days, whatever, 14 days, excuse me, those 14 days. That's a whole different question. And it would be very easy to say, no, while the person finishes out his term, while he cleans out his desk, whatever it is, he's still officially whoever he is. I don't think that's a huge impediment to the. And let me tell you about Justice Gorsuch. I mean, you know a lot about him too. But he loves.
Here we go.
He loves being clever. He loves being what he thinks is erudite and making these points no one else makes. The legal implications of someone being an insurrectionist who is currently in office is an issue that doesn't have to be resolved in the way he suggested. And I think we have lame duck presidents. We have all kinds of things. So I don't buy that. What I do buy, though, is I don't know how to solve the problem of 50 different state procedures. That's more difficult. Now, I think what Will and Michael, the authors of that 126-page article, what they anticipated was a ministerial kind of Secretary of State. No, you're disqualified. Then they file suit. Then it goes to a court, and a court decides. But it's not a ministerial act, because whether or not Trump engaged in an insurrection is not a ministerial decision. Whether he's 35 is ministerial. Whether he's a citizen is ministerial. This is not. This requires applying law to fact. Now, had Trump broken into the Capitol himself and wielded an axe, different story.
I mean, if they take it right, he wanted to. He clearly wanted to get in in the Beast, the limousine, and he was pissed that they wouldn't take him to the Capitol so that he could lead his people on that assault on Congress. It's an interesting counterfactual, because clearly that's what he intended.
And by the way, can we just pause for 1 second and just let me rephrase that. Let me pause for 1 second just to once again reflect my agony that we're still having these conversations about this malignant narcissist who has no business being in public office and only ran for public office to pad his wallet. I just can't believe we're still talking about Donald Trump, but we are, so here it is. Going back to the oral argument, it was shocking to me that only Justice Sotomayor seemed to push back on all of the arguments. She was the only one who seemed to be even considering the possibility of disqualifying Donald Trump. And I think what's happening there, and I think it makes sense, is, of course, there's a lot of partisanship going on. What must have happened, Liz, I have been saying for months that they will do whatever they feel is in the best interest of the Republican Party. That's what the Roberts Court does. Senator Whitehouse has toured the country saying, in his words, 100% of election cases, now it's 99%, go in favor of the Republicans since Alito and Roberts took office in 2006. He's wrong on the numbers. It's only about 97%, but
but it's pretty bad.
Yeah, it's terrible. It doesn't matter. 3 of these justices were on the briefs in Bush versus Gore. We know they're going to do what's best for the Republican Party. In Bush versus Gore, Justice O'Connor told us at a cocktail party what was best for the Republican Party. Elect George Bush. So, there was no question. The only hope I had for this, not hope, I shouldn't say that. The only expectation I had this might come out differently would be if Kavanaugh and Roberts decided, or Barrett and Roberts, or 2 of the Republicans decided, you know what? It's in the best interest of the Republican Party to shelve Donald Trump, let Nikki Haley run for president, and we'll all be better off. That was a possibility. They might have thought that. It turns out they didn't. It turns out they don't.
All right, we're going to be back. We're going to take a quick ad break, and we will be right back. Okay, we are back. Professor, I want to ask you a specific question because I talked about it in the intro. Can you walk us through the nightmare scenario that's described in the amicus brief filed by Professors Hasen, Foley, and Attorney Ben Ginsberg?
And let me say I have the hugest respect for all three of those people. We're
Absolutely.
different degrees of liberal and everything, but still unbelievable respect for all
Well,
of them.
I mean, Ginsburg's not a liberal.
Right.
I mean, he's a Republican election attorney
Yes.
who just hates Trump.
Right. They were all, well, Trump has made a lot of conservatives appear a little bit liberal these days. It's a weird.
I know. Sitting on the same bench as George
Yeah.
Conway is a strange place to be.
Yeah, it's a weird dynamic. Of course, Trump breaks everything, so who's surprised? Anyway, so let's take Rick Hasen, because he wrote that. He said those things in that brief, but he's also been talking about this other places. I think Rick is the leading election law expert in America. So I have a lot of faith in him. But they're all worried about the following scenario. It's not going to happen now, so it's hypothetical. But they are worried that if the court does something that delays things or doesn't end this controversy, that they could say, for example, there was a defect in the state procedure, do it over again, because there were some questionable defects. They admitted into evidence some things I'm not sure should have been admitted into evidence and other stuff. Their concern is we need an answer from the Supreme Court now, because we need to know who we're voting for in November. We need to know who the Republican primary voters are voting for in July, and so on and so forth. They're absolutely right. Whatever the court does, it has to be either he's disqualified forever and ever and no one can change that, or he's not disqualified and he's not going to be disqualified. It has to end. This has to end. They are correct. It is a nightmare scenario. What Rick Hasen has been saying for a very long time is, and he wants Trump, he probably wants Trump disqualified. I don't know his personal views. He's not a Trump. He's not a Trump supporter.
No, he definitely is not.
Yeah. But what he's saying is we need an answer one way or the other. It must be definitive. He's concerned if it's kicked back to the states, that's the worst scenario, because then we can have 50 different procedures. Even if it's kicked back to Congress, they're concerned because that still leads to some uncertainty. What I'm saying is I don't agree with Rick about that. If the Supreme Court kicks us to Congress, nothing will happen and we don't have to worry about it. He's not going to be disqualified. Now, the reason this is all very important, though, is because Section 3 only applies to people holding office, not people running for office. That was Rick's fear. Rick's fear was the Supreme Court would say, this case is not ripe. Go away, come back tomorrow if Donald Trump wins the election. That's what they're worried about.
Yes, because Justice Alito, I think, touched on that there is this kind of theory that they could say, well, you can run for office. It's just a question of whether you can get seated for office. And to be fair, there is some historical precedent for that. There were Confederate officials who ran and Congress refused to seat them. And so that would kick it to Congress to decide if these were people who could get seated or, certified in the election, and that would be really dangerous, particularly with the Congress as constituted now. But I agree with you after the hearing, that seems not the way that they're going to get out of this one.
But I do want to make a point about this. This is about constitutional law, not about Donald Trump. This is about constitutional law in the Supreme Court. If we believed in text, which we don't as a system, but if we pretend we do, but we don't. If we did, this is actually required. Section 3 is not imprecise about this. You can't hold office. It says nothing about running for office. If we believed in text, we would say it only disqualifies people from holding office. Throughout constitutional law, though, we go beyond the text, we ignore the text, we do things inconsistent with the text. I know the Roberts Court wants to pretend that's not true, but it is true. And it's especially true for the Roberts Court, in all irony. But as you were starting to say, Rick's concern, which is very well founded, is not going to happen, because what they're going to say is before anybody can disqualify Donald Trump, Congress has to pass a law, and Congress is not going to pass a law, and that's going to end this debate.
Do you think that's the right answer? I mean, you've thought about this a lot I
do. I think it's the right answer because insurrection is not self-defining, and the facts here are unclear. I believe it's very possible if I were a judge hearing the evidence, I would find he engaged in insurrection. I think it's very possible I might say he didn't. If he was 33 years old, I would say disqualified because it has to be 35. But this is a question of applying facts to law to facts. The law of insurrection is unclear. My friend at University of Maryland, Mark Graber, who's an historian, he's a law professor, but he's a good historian. He's not fake history. He's real history.
I went to Maryland Law, so
okay.
I'm for it.
Excellent. Mark would say, my role as a historian, his role, is to show you the history. But that doesn't mean you should do what history says. That's a role for judges. My role as historian is just to show you what history says. I think that whatever happened between 1868 and 1880 with Confederate people trying to be in office and all that, that was then. And we're living in a very different time right now. If you took up arms against the North or you supported the South with military aid or financial aid, you engaged in insurrection. You were trying to do something that was an insurrection.
Right.
Maybe Donald Trump did that, but it takes a lot more work to get there. And when he has 70 million supporters and he's a front runner of the Republican Party, we have to be sure, and we're not. So from the very beginning, I have made two things clear. I hope Donald Trump is never president again, or any office ever again. And I don't think he should be disqualified because it's not clear. Neither the law nor the facts are as clear as they need to be.
Yeah, I felt a little uncomfortable myself in the past couple of months because there are so many liberal commentators, and I am a liberal commentator, but so many liberal commentators who have said it's so clear, it's pellucidly clear that, this is insurrection, and if you just apply the law, and not only do I think, I'm not sure that I agree, although, I can see their point, I worried that it was feeding hopium to a lot of the supporters who were like, well, the court won't be able to get around it because Justice Scalia said, this thing one time and it was discovered. And now what are you going to do? Like, the court was always going to do what the court was going to do. It was only a question of how.
And I think for your audience, I think the most important point here is what you're describing is all of constitutional law. So let me put it this way. I have incredible respect for Justices Ginsberg and Marshall, two American heroes, the most important civil rights litigator in American history, Thurgood Marshall, who argued Brown versus Board, right? The most important gender discrimination lawyer in American history, Ruth Bader Ginsburg, and it's not close. It's not close. And she did it brilliantly against all odds. They both did it against all odds. Yes. Then they go to the Supreme Court. And they vote progressive 99.9% of the time in cases involving progressive stakes. Scalia, Thomas, Alito vote conservative 99.9% of the time. Even Scalia, yes, 99% of the time in cases involving stakes for the Republican Party, for the Democrat Party. So what we learn from this is text, history, and precedent don't mean anything. They'll always do what they think is best. And in the context of Trump's disqualification, my hobby horse has been this. The Supreme Court is never going to admit to asking the following question. Is the country better off or not with Donald Trump being disqualified from running for president? Not some future case, but is the country better off with Donald Trump running or not, being disqualified or not? I think that's a hard question. It's the only question, right? It is actually the only question. And they're never going to ask it. And so we have a political veto council at the top of our food chain that is going to have the final say, likely, on one of the most important political issues of our time without ever addressing the real issue, which is should Donald Trump be disqualified. Instead, they're going to rely on these legal things and legal rules and mumbo jumbo. And that's a bad system. It's not a good way of running a country. And the Trump case is just another example of that. Your point was that they'll do what they want. The best example of that's affirmative action. There is no scenario where the original meaning of the 14th Amendment prevents affirmative action. There is no text preventing affirmative action. The word race isn't even in the 14th Amendment. For 50 years, we've had affirmative action approved by the Supreme Court. Once they got enough votes to overturn it, they did, based on nothing but their policy views. The liberals do the same thing, though. This is a nonpartisan critique.
Yeah.
What Ginsburg actually hinted at most of her career were two things. She said one thing, she hinted at one thing. She said Roe was too much, too fast. Now, Ruth Bader Ginsburg was pro-choice and pro the abortion right. She was. But she also said Roe was too much, too quickly, and she's correct. This country suffered dramatically from Roe being too much, too fast. I'm pro-choice all the way down. I've been since I was 13. But the other thing she said all along was the Equal Protection Clause might have been a better way to do abortion than this unenumerated substantive due process right. And I think she is right about that. The Supreme Court's decisions, there were three of them, including Dobbs, that say restrictions on pregnancy or rules about pregnancy are not gender classifications. It's absurd. Doesn't make any sense. They've said it 3 times. But had the Equal Protection Clause been the original source in Roe, maybe that would have changed. But let's all just remember, when it comes to Trump's disqualification, abortion, affirmative action, campaign finance reform, the administrative state, it doesn't matter what the issue is. Liz, if you and I were on the Supreme Court and we had unreviewable power for life, if we could get 4 people to agree with us on it for other people, or 3 in your case, we'd agree on everything. Liz and I agree on everything. We've got to find 3 more people.
I did not agree with you about Roe being too much too fast.
Okay,
I'll just put that up there. Yeah.
You didn't agree with Ginsberg saying Roe is too much too fast. Not Segall.
Yes, correct.
Okay, well, I tend to defer to Ginsburg on those kinds of issues. But leaving that aside, they'll do what we would do what we want to do. You and I would do what we want to do because we have life tenure.
I mean, this is like a trolley problem married to the Supreme Court, right? Because, like, you know, if you could, like, trade in your integrity or your judicial,
I'm not saying that.
Grab them in and save the country.
But Liz, I want to be clear.
Yeah.
I don't. Okay. Obviously, there are some justices I like more than others, right? Obviously. But there's almost no human being who can hold that position and retain their humility and their modesty and their sense of. Now, Justice Souter did. Justice Souter was the most successful justice of keeping his feet in the real world. And by the way, he's not a real world guy. He's a very theoretical academic guy. But he understood, I think, the office was too much. And that's why he quit early, right? Who quits the Supreme Court early? Only Justice Souter. Because he recognized that.
And a lot of these guys were pretty arrogant when they walked in the door. Like, they didn't, they didn't get arrogant when they took that robe.
Yes, although they get much more arrogant, and so would you, and so would I. It takes an enormous amount of character to not. Listen. There's a cardinal rule of representative constitutional democracy that every other country in the world follows except for us. It's not complicated, and I've yet to meet a human being who disagrees with us, who believes in a free country. Never give government officials largely unreviewable power for life.
Yes.
No other country does that.
I agree.
We don't do it anyplace else. Most of the problems with the Supreme Court boil down not to politics, not to conservative or liberal, but boils down to a simple fact. No human being should have that job. No human being should have that job.
All right. And I think that's an excellent place for us to leave it. Thank you so much, Professor Segall. I really appreciate it, and I hope you'll come back soon.
My pleasure, Liz. Thanks for having me.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Up to Media, LLC, all rights reserved.